more on this, we have Amos Jones, a professor of constitutional law, back in the studio with us. Amos, great to have you with us. Appreciate you coming back. So there's two separate things going on. There's Trump's phone call with Ukraine's president, and then there's also this separate probe that we know the Trump administration has been leading into the origins of the Russia investigation. In terms of the president's motivation, are these linked?
In the mind of the president and the White House, they're linked and they have to be linked. The president is the chief executive of the United States. The intelligence organizations, agencies, come under the executive branch for the enforcement of the law. If there's an intelligence failure or a glitch, the president owes it to his constituents, to the public, to do these kinds of investigations. And it appears to be the thinking of the White House that these matters could be linked, at least enough to investigate them with other heads of state beyond the Ukraine.
The media has really hyped all of this up, but are these actions necessarily different than what we have seen past presidents do? Is it that perhaps the fact that President Trump is more under the microscope?
President Trump has been the target of impeachment since the day he won the election. And so we've seen a lot of backfiring happen. This president really is like Teflon Don. Not a lot sticks, and he's going to outcommunicate his foes. However, this one's a bit different. We don't know whether previous presidents have asked for this type of enforcement. For example, in trying to bring Julian Assange to justice, so to speak, or any other whistleblower who flees the country. What we don't know is not knowable at the moment because of the classified materials. The president's defense may, in fact, declassify all of those previous phone calls of his predecessors so that we can see the extent to which his predecessors probed foreign leaders for information to get to the bottom of these problems with our intelligence and other things.
So this is interesting, Amos. You have represented whistleblowers in the past, and you're currently representing whistleblowers now. We know that this particular whistleblower, his identity is being protected, but the White House has also requested the sources of the whistleblower because most of this was secondhand information. Trump was calling again today for the name of the whistleblower to be made public. Can you just walk us through the legality of where the whistleblower is protected and what rights the president may have to those contacts?
There are various whistleblower protection statutes in the United States, some of them affecting and protecting military personnel, others general civil servants under the Civil Service Reform Act. There's a whole administrative private court system, the administrative judges of the American Citizens Protection Board. Whistleblowers are designed to make sure that nobody in the government is above the law. But whistleblowers are not above the law either. And what's interesting about this whistleblower, who enjoys more protections than any client I've ever represented in the federal government, now or in the past, is that this whistleblower had the benefit of an altered reporting form that enabled this to be fast-tracked into the Senate and House committees. The Department of Justice found that under the whistleblower laws affecting this particular source, there wasn't enough there to directly and immediately report this to Congress. So this whistleblower seems to be being coddled. At some point, the whistleblower's identity will be revealed, and there's no other way to assess the credibility of these allegations.
Quickly before we go, Rudy Giuliani has been subpoenaed by House Democrats. How does the fact that he is Trump's personal lawyer complicate the information he may be able to provide?
Rudolph Giuliani, as the president's personal attorney, may not breach the attorney-client privilege. The president is the holder of that privilege. To the extent the president absolves Giuliani of that privilege, Giuliani can come and testify and talk about whatever he wants to. There's no reason with a hostile committee and a hostile Congress for the president to authorize his personal lawyer to talk about all of the correspondence and communications they've had. Congress may find Giuliani in contempt the same way Congress found Eric Holder, President Obama's Attorney General, in contempt of Congress previously.
All right, Amos Jones, great to have you back. Appreciate you being with us.